The more you talk over me, I will continue to mute you.
Ma'am,
I'm telling you that the number that shows up on the system is not an updated number, but you refuse to listen to me. Additional $69 starting April 1st.
Okay. You said 30, you said she'll pay me what? This kind of been just like she'll start paying, I guess, when the court date is coming up, and then it just goes away. And, my son is still, I'm fully with me, and I'm just trying to figure out, like, I guess I've been on the other side of things before when I haven't had a job and, haven't had, been on child support. And I've just seen the ball start rolling a little bit faster with license being suspended, the possibility of incarceration, things of that nature. When will this?
What we can do for Mr. Tullis?
Yes. Okay, Mr. Tullis, this is where we are right now.
Right from the start, this hearing gets tense. The judge warns, the more you talk over me, I will continue to mute you. Why? The child supportee's figure in the system isn't updated yet, but Ms. P isn't hearing it. The court confirms a new payment plan, $345 monthly plus $69 extra starting April 1st. For Mr. Tillis, that sounds like long-awaited accountability, but Ms. P is already gearing up to challenge the math. This clash between the official record and a frustrated parent sets the tone for everything that follows.
Because she's eligible for contempting now. If the court finds that she's in contempt and she's not paying and she has the ability to pay, then what will happen is she will go ahead, the court will set a purge. If she doesn't pay the purge, then there's the possibility of incarceration. I need to caution everybody listening in that this is civil, this is not criminal. So Judge Manning doesn't have the legal authority to just lock someone up until they paid the full balance of a purge, because that's what we call debtor's prison, and you don't have that anymore here in Georgia. If she is not working because of barriers to like education, criminal records, or things like that, there are services that we can help give her that will get her on track so that your son is getting or you're getting assistance for your son, or if she's not employed or something. But those things are happening right now. So nothing's different depending on whether you're male or female, mom or dad. Whoever is supposed to be paying that money to child support, the same steps happen that happened before.
Okay.
As far as we're concerned, it's only about your son at this point. We play no favorites here.
Right, exactly.
Or at least I don't.
Mr. Tillis tries to pin down the process. He's seen consequences, license suspensions, even jail threats, move faster when dads fall behind. He asks, what if she doesn't pay? The court explains, first, arrears are locked in as debt. If she skips payments for 60 days, administrative penalties like license, passport, or tag suspensions automatically begin. At 90 days, the case can escalate to contempt, and only then does jail become possible if she has the ability but refuses to pay. It's a civil process, not criminal. The judge can't just imprison someone until a balance clears.
Yeah, I surely do appreciate it breaking that down for me. I just want to know how the process went, and that's kind of clearer. So, like, we're looking at now, April. You said, this 345 plus the additional 69 to start.
Yes. And if she's not paying child support like she's supposed to consistently now, then they'll start reaching out to her to ask if she needs services. And if she doesn't respond, then the regular, we have to do the admin part first, which is suspend licenses and all of that. And then it can come to contempt. And unfortunately, we may have to ask you to come back to say that you haven't received anything later on down the line. But that's how the process will go from here on out.
Let me add this that I know. She hasn't had a license in years due to suspension of her license for drunk driving and things like
Oh,
that.
we don't need this because
Oh, I'm
it's being
sorry. I'm
broadcast.
sorry.
Okay,
I'm
that's
sorry.
okay.
I'm sorry.
We're gonna need this.
Um,
Yeah, that's okay. That's okay. I understand.
The judge emphasizes neutrality. It's only about your son. We play no fence here. If Ms. P is struggling because of barriers like education gaps or a criminal record, state programs, like employment services or bonding, can help her get back on track. The Parent Accountability Court, PAC, program, run by another judge, monitors and supports parents to ensure consistent payments. This reminder that the same enforcement steps apply regardless of gender is an important public takeaway. Child support rules don't favor moms or dads. They follow a process designed to benefit the child.
For contempt more quickly if she's not been making payments consistently. I don't have her last on my note. Agent Ms. Freeman, can you see when her last payment was?
Her last payment was made on January 31st in the amount of $85.80.
Okay, that's relatively low. So, but a payment was made, and so that's going to trigger the clock to start over. But what I'm going to ask our PAC coordinator to do is reach out and see what's going on. If you can for me.
Yeah, I'll
And
go ahead
then
and reach
let
out
me
to
know.
her.
Because if I do need to file something, I can, if she can fit into the program so that we can get consistent payments then. Okay, Mr. Tillis, I think you've heard Judge Manning talk about the PAC program a little bit, and what that's called is parent accountability. And what's different about that from fatherhood is that it's governed by the court.
With Ms. P absent earlier, the court adjudicates arrears at $4,292.59 as of February 28th. Ms. P later argues the balance should be closer to $2,900, claiming some payments weren't credited. The court clarifies the system's displayed number lags behind real-time calculations. Only after a hearing can affidavits, like Mr. Tillis's sworn statement of mispayments, be added to the record. That's why the total jumped to $4,292. The added $69 a month repayment is specifically to chip away at that arrearage while maintaining her regular support obligation.
To do, and if there are any other barriers, she can help provide services from the state. Not that this is the case with the current CP, but say, for instance, if a criminal record is preventing them from being able to get a job, the state will provide what's called a bond to assure the company that there will be no problems, and then that person can go work. So if there's a job out there, Ms. Freeman will find it for her.
There she
Okay.
is.
Okay.
There she
Will
is.
will I get a copy of this?
Oh, she's back.
Oh, okay.
Order? Yes. Okay, I believe, well, okay. Well, we're done. So Ms. Pate, what's happened is this was an adjudication of arrears. This is the last case on the calendar. And so the court proceeded to go forward because we need to let Mr. Tillis go back to work. The arrears were adjudicated at $4,292.59 as of February 28th. Your current child support payment is
$32.59. That's the amount that's in the system. What's the $4,000?
Because when you looked into the system, we can only start charging for the amount of time until we get to this, which is an adjudication of arrears. Mr. Tillis provided what's called an affidavit, which was in the packet that you received when you were served. And that's the amount.
Ms. P insists the math is wrong. You don't add $1,360 to $2,900. She references payments sent directly and through wage withholding, IWO. The state's attorney responds, unless she presents receipts proving additional payments, the affidavit stands. The judge doesn't need repeated testimony. He trusts the earlier record. Ms. P.'s frustration, believing the system's online figure is the final word, is common. But in child support law, only adjudicated amounts in court count, not temporary or lagging numbers on a website.
That we are adjudicating right now, that has been added to that $2,000 in the system. to bring your total up to
But you're not supposed to add that to the
$4,292.
$2,000. That's included in the $2,000. The reason why I'm saying that is
That's what court is. That's what court is for. That is literally why we are here
what I'm
today.
saying is,
Hold on, ma'am. Listen to Ms. Clark Davis.
I hear her. No, what I was saying was the
You're not listening to her
$1,000.
because you're talking over her, so I'm muting you. Go ahead, Ms. Clark Davis.
So we can't put on the system the arrears affidavit until the amount that's on the arrears until we've had a hearing. We had a hearing today and we added that information to the system. You have paid Mr. Tillis that money from the affidavit. We're open to seeing the receipts.
Okay, but this is what I'm saying. When we received the complaint for child support, when it says that we owe the $1,360, then that's as of 7/7/2022.
As Ms. P continues to interrupt, the judge warns, "Stop unmuting. Unmute yourself one more time and I will remove you." Her repeated objections, "I do not owe $4000," clash with the court's explanation. The displayed balance is outdated. The judge mutes her multiple times to maintain order. This moment illustrates a crucial lesson. Even in virtual hearings, courtroom decorum matters. Talking over a judge can hurt your case and delay resolution, especially when official calculations, not the online portal, determine arrears.
The only thing that's added to the $1,360 after that is the $354 that's supposed to be paid monthly. Mr. Tullis has received monies through IWO, and he's also received monies through direct payment. So another arrears affidavit needs to be completed by Mr. Tullis. As of January 31st, Mr. Tullis has received at least a payment of $1,000 on the case. So that arrears balance needs to be done over. The $4,000 is not correct.
Your Honor, do you need to hear the text?
Then we don't add the $1,360 to the $2,900. The $1,300 is as of July 2022. The $2,900 is as of February 2023. If we do 3 times 12, that's like what?
To close the loop, Mr. Tillis is told he'll receive the signed order by mail. But if he emails the court after Friday, they'll send a digital copy. The court ensures he has the correct address, court120@dhs.ga.gov, mail to court120@dhs.ga.gov, to avoid further confusion. Meanwhile, Ms. Freeman, the PAC coordinator, will reach out to Ms. P to connect her with employment or payment assistance. This step isn't punitive. It's meant to prevent contempt actions by helping her succeed before enforcement escalates. The hearing wraps with a firm reminder. The system display is not the final balance. Only the court's adjudication counts. Ms. P.'s repeated unmuting got her removed, underscoring the importance of listening in court. For parents watching, if you dispute arrears, bring receipts and affidavits, not just screenshots. And remember, enforcement, like license suspension or jail, kicks in only after formal steps and chances to comply. This case shows both the law's structure and the emotional tension child support disputes can trigger. What's your take? Should the process be faster, or is this cautious approach fair?
She's frozen, and I'm absolutely happy with she hasn't presented anything other than what she thinks that the math is done wrong.
Thank you, Your Honor. Then we'd ask that that be the final order of the court. Mr. Tillis, am I frozen too?
Yes, ma'am.
Oh, okay.
Yes, ma'am.
All right, Mr. Tillis, then everything stands as we discussed just a moment ago. Ms. Freeman, I still need you to reach out to Ms. Tate when you have a moment to see if she needs any additional services.
Will you guys send me this information today?
Yes, sir. Well,
Okay.
as soon as the court signs the order, you'll receive a copy in the mail.
Okay.
Oh.
I don't have it in my chat. Can you say it to me one more time so I can write it down?
Yes, it's court, COURT 120 at dhs.ga.gov.
At DHS.
Dot
Which is
GA .gov.
.gov. And you said I need to send an email to you guys, or you?
Yes, if you will send an email to us so that we have your email address, we'll send you a
Okay.
copy of the order.
Okay, so
Thank you.
all right, so I just went on the system now, and the arrears balance is only $3,277.59.
System's not an updated number.
Do you
The
guys still need
updated
these
number
numbers?
is $3,270.
Yes, ma'am. Yes, ma'am. Yes, ma'am. The number that is on the system
Legally,
is
you're
not an
illegally
updated
maintaining.
number. The number on the system, once again, is not an updated number. It is behind. Stop unmuting yourself,
Number.
because the more you talk over me, I will continue to mute you.
Ma'am,
I'm telling you that the number that shows up on the system is not an updated number, but you refuse to listen to me.
ma'am, when will I
It
get
is
a
not
copy
an
of the court order?
updated number.
Because I
You
don't have
are
no
not listening. Okay, unmute yourself one more time and I will remove you. That's it. Goodbye.